Yeah.
Because I asked earlier about whether there's a capping or there's a maximum number of justices that can be appointed to the Supreme Court. There's always a reference to the United States where 9 judges by legislation are appointed to the Supreme Court. Should the numbers be fixed, in your view, having served as Chief Justice?
I don't think so. It's not necessarily, you see, because I would always come to the question, in what way will numbers assure quality justice? In what way will numbers ensure timely justice? In what way will numbers necessarily impact on efficiency and so on and so forth? So, as I have already said, and that is why I've always found it difficult to completely agree with a capping. I've always felt that 15 is a perfect number. Why? Because 15 gives you straight away 3 possible panels so that you can be doing your normal cases. But that also will depend on the caseload in the registry, the demand. How many cases are otherwise ripe for hearing, but everybody is exhausted? Yes. And 15 would be perfect. 15 could also be that there can be 2 courts even sitting simultaneously to do cases. But 15 may not be what is required if most of the cases coming on are constitutional cases where you need 7 to sit on the case. Yes. So it's all a question of the demand. So and please, the U.S. Supreme Court sifts, they filter. And to a large extent, one can say the formula is arcane and known to them. But primarily it is if the matter raises a novel issue, or things have changed so much since an old precedent, and now the court should take a second look, like Roe and Wade. I never thought that Roe v. Wade would be thrown out, but they've done it, okay, because they felt that the times have changed, okay. In Ghana, appeals alone, once somebody has filed an appeal and lost in the Court of Appeal and feels like, and that's how I will put it, because some of the appeals that land in the Supreme Court are based on feelings, not on law and facts. Yes, appealing, they can. And if the case started in the lower court, they will need the leave of the Court of Appeal. So, but if the Court of Appeal refuses the leave, they can apply for special leave in the Supreme Court. And in as much as the Supreme Court has tried to define the scope of of what entitles somebody to special leave, people will still try it for luck. And therefore, their application will have to be heard. So we're talking about judge time and sitting time and hearing time. That also affects the numbers, the requirements of numbers, you know. And then there's also review, which is also, strictly speaking, review is as of right, but as to whether it will be granted or not, it is within certain limited parameters. But nothing stops the person from trying it on for size. And sometimes, and to a large extent, a lot of applications for review are nothing more than a second, an attempt to bite another piece from the cherry of appeal.